Hello and welcome to Lokojano podcast. My name is Srishti, host for today's session. Today we'll be talking about a very significant legislation, that is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, or the SARFAESI Act. The SARFAESI Act was introduced to address the problem of non-performing assets and facilitate the recovery of debt by financial institutions without the intervention of court. To understand this act in depth, we have a very special guest today, Mr. Nikunj Dugar. Mr. Nikunj is an advocate and founder of Pivot Legal with extensive experience in advising clients on compliance issues, including establishing policy guidelines and responding to investigation requests. So, welcome to the podcast, Mr. Dugar.
Thank you so much, Srishti. Thank you for having me.
Thank you so much. And before we start, can you just tell us about your inspiring journey to our audience?
I don't think so. My journey has been inspiring yet. So basically, I started my graduation from School of Law, Christ University. I graduated in 2018. Thereafter, I was fortunate enough to join the office of Justice Vijay Sen Reddy. Sir back then was very lucky. I was very lucky that I got an opportunity to work with Sir. Thereafter, when Sir got elevated, the office was taken up by Vivek Jain Sir, and I continued in the office. Thereafter, in 2022, I decided to start my independent practice and founded Pivot Legal.
That's really interesting. Now, coming to the SARFAESI Act, the Act was introduced to ensure expeditious recovery of dues, to reduce the burden of the court, and also to improve the overall financial health of banking sector. So, do you think the Act has been successful so far?
I feel originally this act wasn't that successful. I'm sure before we go into SARFAESI, you are very well aware about the RDDB Act, which came in 1993. That act was not very strong enough, and therefore the Parliament thought that it's better to have a 2002 legislation of SARFAESI. Now, the most important thing about SARFAESI law is that there is no court intervention at any point in time for the bank. Only if the borrower, guarantor, or third party is affected by any of the activities or the investigations of the bank, then they approach the court. That's the DRT basically. So I really feel in that way it's been an easier step for the banks. But in totality, if you look at it from a borrower's point of view, it has not been that successful because there has been a lot of times we have seen banks, especially PSU banks, flouting rules and going against the security interest rules and just basically going against the very mandate of the Securitization Act. So you can say it's a balanced perspective for now because the courts have interfered in various judgments since 2002 till today. So therefore, it has become better and better. But I still feel that there is a scope for improvement.
That's really interesting. Like you were saying that the borrowers' rights have been compromised in some way. And we also have seen that borrowers have complained that banks misuse the act without adequate notice or compensation. So do you think the act tries to favor the interest of banks and financial institutions over the rights of borrowers?
Yes, I do feel that the banks are given a priority when it comes to the SARFAESI Act. So basically, SARFAESI is very simple, as everyone knows, that if you don't pay any of your dues, and if you don't pay it continuously for 90 days, then your account is suspended and they make it into an NPA. So once they make it into an NPA, the banks have the right to issue a notice to you under 13(2). That notice is for 60 days time. If they do not repay the amount, as the borrower does not repay the amount within 60 days, then the banks go under both the RDDB Act, that's by filing an OA, and they also simultaneously start issuing possession notices. So when they issue these possession notices, they smartly do not follow all the rules. So as per Rule 8.2 of the security interest rules, they are supposed to place this before the in a conspicuous place, basically in the property. They are also supposed to make sure that they publish it in two newspapers, one being a vernacular newspaper, but they don't follow all these rules. Most of the times, only when the borrowers approach the DRT under Section 17, we found out that actually the banks did not follow all these rules. So it is usually more or less advisable that people go to and file a Section 17. So they find out that because the banks under the SARFAESI Act are not mandated to share all these procedural irregularities with the borrower or the guarantor. So the banks flout it because they think that the borrower or the guarantor will actually not end up going to the court. So they do not follow anything. They just, in a hurried manner, take physical possession of the property. And once they take physical possession, they arm wrestle with the borrower or the guarantor, and they finally sell the property. If not sell the property, then coerce the borrower or guarantor to pay the amount. There have been cases in my own experience in which we have got rules, we have got various judgments in favor of the borrower, but then the borrower was coerced and pressurized by the banks, and he had to settle in spite of banks not following rules. So this is a very regular and SARFAESI Act. That's why it's not completely foolproof when it comes to the borrower and the guarantor. It safeguards the interest of the banks more, and I honestly feel that is what it was intended to do. But somewhere borrowers need also to be safeguarded.
That's a grey area. Now, coming to the recent Supreme Court judgment, Supreme Court held that any remedy against an order of magistrate under Section 14 of SARFAESI Act can only be availed under the SARFAESI Act itself. So, can you just elaborate to our audience about the remedies available under the Act?
Okay. So basically, what the Supreme Court stated in that matter was, after the Section 13(2) notice of demand notice is issued, a 60-day time period is given. Now, in that 60-day time period, the banks, after the end of the 60-day time period, are supposed to issue something known as a 13(4) notice. That is a symbolic possession notice. Once they issue a symbolic possession notice, they can then approach the CMM court, that is the Chief Metropolitan Magistrate Court, or the district magistrate, to apply for physical possession of the property. Now, the point of concern over here, which in some matters it was raised, was, I think this was a 2022 judgment, in which the party was Capital First. So against Capital First, one of the parties stated that CMM court and district magistrate only have the right, and additional CMM court or additional district magistrates do not have the right under Section 14 to entertain any application. So now the Supreme Court went into detail in this matter, showcased various rules and everything, and finally it came to the conclusion that CMM courts and additional CMM courts, exactly like district magistrates and additional district magistrates, hold the same power. So you cannot differentiate them, and they will have the right to entertain Section 14 applications. But now the problem in these Section 14 applications for the borrower, if I may tell you, that is, in Section 14 application, it is only a ministerial act which a CMM court or the magistrate court is handling. They are not giving notice to the borrower. There is no requirement of the borrower. It is only between the bank and the court. The bank has a certain application. They fill in that application, file all the annexures along with that application, and present it before the court. Now, it is the court, after looking at those annexures, finally decides whether physical possession of the property can be given to the bank or not. If they decide, in 9 out of 10 matters, they appoint somebody from the bar only, who will be an advocate commissioner. Now, the advocate commissioner is supposed to give a notice to the parties. Now, the problem over here is, when they give notice to the party, they are also supposed to give notice to the person staying in the property. Sometimes it may be that I have given a property of commercial nature as guarantee. So there will be a tenant. My tenant will be staying in the property, or maybe my relatives or anyone else is staying in the property. So in spite of only giving notice to the borrower or the guarantor, they are also supposed to give notice to the tenant. Now the problem over here is they do not do that. Because under Section 14, the banks also take the right of police protection, break open lock and everything. Because of that, they directly go with the police, break open the lock and take physical possession of the property. Until and unless the tenant, the person staying in the property, the borrower or the guarantor actually approaches the DRT. And as you are aware that in the between, there were not even a lot of judges available in the DRT. So that's another point of concern which a lot of people have, because if there are no judges in DRT, they cannot approach the civil court or any other court. It is very clearly given that because RDDB Act and SARFAESI Act both are special statutes, you cannot approach a normal civil court or a high court. You can only approach the DRT, and only in exceptional circumstances does high court take it into consideration. So this is actually a major issue which all borrowers and tenants face when Section 14 application is taken, because they strong arm the person living there because they have police protection and everything as per the law. Only if Section 14 could be amended in such a manner in which if the borrower or the guarantor is at least given one notice, one chance to appear before the court and explain to the court his side, then this would. But the Supreme Court in that judgment, which we are talking about, the Capital First judgment, they made it very clear that it is only a ministerial act, and therefore no notice to the borrower is required. So this is technically the Supreme Court gave the right judgment as per law, But it is the wrong judgment when it comes to looking at the rights and liabilities of the borrowers, because now it is putting additional burden on the borrower, because he's not having any other remedy except the DRT, and DRT also most of the times are giving mechanical orders by only giving 20% or 30% stay orders. That's another issue.
That's really interesting to see from the borrower's perspective. Now, coming to the other side, the Act allows lenders to take possession and sell the assets of defaulting borrowers. But it has been reported that the whole procedure takes considerable amount of time and resources. So, do you think this is one of the major drawback of the SARFAESI Act?
If you follow the rules and if you have a proper intending purchaser ready, I do not think it takes a lot of time. Only if you flout the rules, if you don't follow. So basically, there's a procedure laid down. Like I said, 13.2, you have to give a 60-day notice. Thereafter, 13.4, you have to give another 60-day notice. Thereafter, there's an auction notice. Now, in the auction notice, you are supposed to give a 30-day time limit and also publish it in a newspaper. Now, what the problem here before was, under Rule 8.6 of Security Interest Rules, people had this confusion that Rule 8.6 and Rule 9.1, being the two different rules, are to be read not simultaneously but in two different hemispheres. So, Rule 8.6 they used to give 30 days, and Rule 9.1 they used to give 30 days. But that is absolutely clarified by the recent Supreme Court judgment and also by the judgment of the Telangana High Court in the Vinayak Steel matter. So, in this matter, the Telangana High Court made it very clear that Rule 8.6 and 9.1 are to be read simultaneously, and they are together supposed to be given only 30 days period. So if you calculate the entire timeline, it is 60 plus 60, that is 120, plus another 30, that is 150 days. So it's only 150 days which will take for the borrower, for the corporate debtor to lose his property, and for the lender to get back his rights, if he follows all the rules. But the problem over here is they do not follow all the rules, because actually, if you look into it, it is a little expensive to follow all the rules, because they keep having to publish newspaper articles and newspaper notices to showcase that this property is going on auction and everything. And also, there's a major stigma in our country as well when it comes to buying a litigation property. So because of that, they feel they do not get the rights. And even as per the rules of SARFAESI, they are supposed to not sell a property below the market rate. So the market rate is determined by an approved valuer. A lot of times, the major dispute point between the borrower and the lender is the fact that the approved valuer is not giving the right amount as the compensation amount. He's basically, the reserve price which is being set is very low. So because of that, the borrower feels that his rights are getting violated. And that is the reason DRT steps in and then gets into the entire litigation aspect of it. So the auction purchaser who actually purchased the property will hesitate to buy the property, because he will always have this sword hanging over him that when can the borrower come back and redeem the property. Because as you know, auction purchaser is very strictly given in the SARFAESI rules and in the security interest rules, that the auction purchaser has to pay the entire amount within 15 days from the date of auction. Entire amount, even if he gets possession or he doesn't get possession. Because if he even flouts one of that, then the entire auction is said to be vitiated and fresh proceedings have to start. And the EMD amount which he paid, that's earnest money deposit, that also gets forfeited. So a lot of borrowers hesitate to enter into transactions with the banks because of this reason. And therefore, you can say lenders in totality feel that it takes a lot of time. But if they actually follow the procedure, I don't think so. They should take more than 150, maximum 200 days to get their amount back.
To come to the end of the section, that although SARFAESI Act has been successful, the issue of non-performing assets still remains in our country. So what do you think could be done to improve the whole NPA situation?
Honestly, I feel the NPA situations are going bad only because banks are giving loans left, right, and center without any mortgages or without any security interest. They are not having proper due diligence. We see on an everyday basis that the persons who've actually been given loan, they are giving collaterals higher or sometimes even double the amount of the loan taken. But that only when you start seeing the big banks who give it loans to the big corporates. There, they have no collateral sometimes, and sometimes even when they have collateral, if the loan is for assuming 1,000, they will only have a collateral for 100. So because of this misbalance on the top end, they are facing a lot of issues, and therefore when you see the total bottom line of the banks at the end of the year, we see that there is a lot of issues. But in reality, if you see, a lot of NPAs are getting resolved. That is because of the fact that banks have now become more stringent, more diligent. I think because of the RBI rules and everything, becoming more diligent and stringent. And they are making it very clear that if you want a loan of X amount, you have to minimum give 1.5x worth of security. Only then can you expect that to get a loan. If they follow the same methodology with corporates or with big companies or big individuals, as they say, HNIs and everyone, then it will follow the same rule. But if they do not, then NPAs in India will be high, because NPA, when we in India, we don't see NPAs as the number of NPAs. We see NPA in an amount. So the amounts of the big corporates will always be higher than an individual person or a small company. Small companies take loans for 5 crores, 10 crores, and they give collaterals worth 12 crores, 15 crores. Even if you sell it at a bottom rate, it will go easily for 11 crores, 12 crores. So the bank's entire interest, along with his entire principal, comes back. So they have nothing to worry about. But again, when you look at the big corporates, they will take loan worth 1,000, but they'll only give collateral worth 100. So even if they sell that 100 worth collateral for 150, there's still a bad debt of 850. So that cannot be helped in any other way. The banks have to be more stringent.
That's really interesting to see. Now, what are your concluding remarks about this whole topic on the SARFAESI Act?
I honestly feel the SARFAESI Act can get a lot better, but we should also consider that IBC has come into picture. Now, what the issue, another very important issue which I feel your listeners would like to know is IBC and SARFAESI together are creating a lot of issues. So banks are going against the corporate debtor under the IBC, but they are going against the guarantor, who usually are the directors or other persons, under the SARFAESI. Because as per the law, if you have to go against the guarantor in IBC, if you have to go against the guarantor under Part 3, then that amount which the guarantor will give will not only be given to the bank or the corporate creditor, but will also be given to all other COC members. Now, to evade the guarantor paying the amount to all other COC members, they are now coming up with a smart strategy and only going against the corporate debtor before the NCLT and the IBC. And for regarding the guarantors, they come under SARFAESI. They keep issuing notices, they take physical possession of the secured assets, and they keep selling it. And when the SARFAESI, when the guarantor comes and talks about the Lalit Kumar Jain judgment and saying that there is a moratorium granted against the corporate debtor, they have a very clear, distinguished saying that it is only granted against the corporate debtor and not against the guarantor. Because of this reason, guarantors are now getting issued. So anybody who is giving a guarantee, I see in a lot of cases in which relatives have given guarantees for people. So before giving guarantee to any company or anything, we should be very careful. That's another issue which we are facing in our country. A lot of people come and tell me that they only believed in their relative or in their friend and gave a guarantee of their property. But then today, the banks are not going against that main company. The banks are only going against this guarantor to make sure that they get their recovery amount. And as you know, even as per the Contract Act, they are liable and they are eligible to go against only the guarantor and not against all the parties. So because of that very reason, I feel there is a lot of issues still going on. But in totality, if I look at the SARFAESI law, it is helping. It is coming up to the standards of what it was actually meant to do. And because of the intervention of the courts at the relevant point and making sure the rules are notified, the rules were revised in 2016. And since then, the recovery rate has also become faster. If I'm not wrong, the recovery rate, even as per RBI since 2016, has increased to 30%, more than 30%. Originally, I think it was around 50%, 50 or 40%. It has now come up to 70% recovery rate, because of the stringent rules which they revised in 2016, which actually came into force a little later. But because of the entire revision, everything got faster. So because of that, in totality, if you see today, SARFAESI laws, originally in 2002, what it was envisioned for, that is basically making sure that the lenders and the banks, basically the PSU banks, get their money back diligently. It is achieved. But borrowers and guarantors are facing issues. So if that can be resolved, and if some small tweaks here and there can be made by the government, then it will be very easier even for the borrowers, because there are a lot of times when we see in real estate loans, on slab rate basis, you get the loan. So now the problem in slab rate basis is sometimes the borrower needs the amount second slab, he needs third slab amounts. But the bank will not give the third slab amount, saying that you did not complete the third slab. Because of that, his entire loan will become an NPA and he will not be able to complete a project. Even when he's ready to complete the project, he's not able to complete the project because the original loan which was sanctioned, for example, of 1 lakh rupees, the entire 1 lakh has not been dispersed. Only tranches have been dispersed, which is creating an issue for him today. So if these issues could be resolved by the government, nothing better.
That's really interesting, and thank you so much for the wonderful session. It was indeed helpful for our audience in understanding this complex topic. If our audience have any doubts or comments, let us know in the comment section, or you can contact Mr. Nikunj via his profile link in the description box. And follow us for more such podcast sessions in the future. Thank you, goodbye, and take care.